Welcome to Season 2 of the Lex Rex Institute Podcast. We've got a lot of exciting things planned for you guys this season. As always, I'm Alexander Haberbush.
And I'm David Truschel.
And this is the Lex Rex Institute Podcast. So this season, we're going to be doing things a little bit differently. One of our big changes, if you're watching this on YouTube or Rumble or one of our Vimeo, one of our other platforms, I'm sure you've already noticed, you can see us. This is a video podcast this season, where last season we just had audio. This season you can see our hideous faces, and we regret having chosen that option.
It may or may not be a positive depending on your perspective, or if you have functional eyes. Right. I think we did post one clip last season, but anyway, you're right.
Our clips do markedly worse than the audio, so I think that shows people's opinions on that. But we'll see if we post the whole episodes, whether or not how those do. But if you do want to watch it that way, we got a lot of requests to be able to watch our podcast visually. So you got the option now, at least. And a few other changes to the format. We're going to be... What's the release schedule now, David?
We're planning, and it's still tentative, but the plan is for bi-weekly releases, so 2 a month, basically. That's the plan. If that changes, and it could, we'll let you know, but that's what we're assuming.
So it'll be following the moon now, rather than the calendar, I guess, is the change there? Or is it still going to be Mondays?
It's still going to be
still Mondays, so you're not following the moon.
Well, that is Moon Day,
That's a fair point. So you thought that the etymology corner, what do we call it, Alligator Alley, I think, something like that.
Yeah.
You thought that was gone, but you were wrong about that. So.
Yeah. Anyway, I feel like this is spiraling wildly off track already.
Yeah. So try. Every other week is going to be the general release schedule. We may modify that going forward. We will be announcing subjects ahead of time. So you can follow either on our website, which a new website is going to be launching very, very soon. May have already launched by the time this podcast goes up. You can follow. That's probably the best place to follow it. You can sign up for notifications. Our Facebook page will also have regular notifications saying what the topics of each episode will be. So you can look forward to whatever we're going to talk about and not be surprised when Monday comes around. You'll know what it is beforehand.
Yeah.
So, any other changes?
I don't think to the podcast, maybe to things in general. Oh, we should thank everybody for the success of our fundraising
drive. Yes, our matching
drive.
I think we called it the Be Thankful for Our Constitution Drive. That ended up getting about $20,000 in contributions, all of which will be fully matched by our anonymous donor. Thank you so much. You know who you are. If you donated to that, we really appreciate it. We could not do this work without those contributions. So that was a huge success. Thank you, guys.
Yeah.
Yeah.
All right.
I guess last change of the podcast, we're going a little less topical this year. We're going to be doing, I guess our segment on the French Revolution was very popular. We got a lot of positive comments on that. Our episode about different judicial philosophies was very, very popular. So we're going to be focusing on more broad theoretical, political philosophy, legal philosophy, jurisprudential type issues rather than citing legal news. Now, don't worry, you're still going to get legal news. We're still going to have it, but the focus is shifting slightly. So that's some stuff to look forward to this next season. All right, without further ado.
Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
That's right. And though our Constitution is not a living document, certainly there are legal developments, right? And there were a lot of legal developments last year. So that's sort of our topic for today. We're talking about the biggest legal developments of Year of Our Lord 2022. Let's jump into our, what is it, a top 7 list, I think is what we have? Or
I think it ended up being 6.
6? That's an unusual number for a top list.
Well, so is 7. I wanted 5. You insisted on more.
I wanted 10, but then we'd be here all day.
Well, so. I thought that was too many.
Well, there's been a lot of argument behind the scenes on this, but we settled on a top 6 list. Camel is a horse made by a committee. This is a top list made by a committee of 2. So our top 6 legal developments for 2022.
Yeah, and it should be noted, not in any particular order. This isn't, from 6 to 1 or anything like that. It's just written down more or less at random.
Yeah, well, and also, there's a lot of things we could have put in here that we didn't, which is why it was kind of hard to narrow it down to this many. And we'll have honorable mentions at the end. But here's our assessment of some of the biggest things that affected your rights last year, because you ought to know that, right? I mean, these things all implicate your rights. If they changed in the last year, you should know that. So, all right, now that I've given it some introduction, David, do you want to introduce the first one?
Sure. So the first one on the list is the court's cracking down on quote-unquote emergency measures related to the COVID-19 pandemic.
Yeah.
And this came in a few different sort of guises.
Yeah, so obviously when the pandemic started, everything got shut down. That included the courts. And when the courts got reopened, their calendars were so backlogged that a lot of these people that had procedural issues arising out of the pandemic, we feel, did not get adequate justice, particularly the huge numbers of people that were subject to various mandates of various kinds, people who were compelled to get mandatory vaccination, who were subject to mandatory testing policies, people like that. There were so many of those cases that a lot of them simply could not be heard before the courts. That started to sort of slow down a little bit, and courts are now finally hearing those cases. And we saw some of those cases decided in 2022. And how'd they turn out?
Well, very often in favor of the people who felt, that their rights had been infringed under these emergency measures or, what have you, which, the Lex Rex Institute has done a good deal of work with people who felt that their employers were imposing on their medical rights, that sort of thing. And more often than not, for us at least, that's gone well.
Yeah. Although we've had a few, even just in this last week, we had some, in my opinion, crazy rulings against our clients. So, there's still a lot of work to be done on this, and we're going to continue to fight those cases. In fact, Victoria Katana, we talked to you about her in the past, a judge recently dismissed her case totally unjustly, in our view, basically saying that there's no recourse here. For somebody who had numerous disabilities that precluded vaccination and testing, we're looking at appealing that, although we do need to get that case funded, and we need funding from that separate from the rest of it. So she has a Give, Send, Go page right now. We'll put a link to that in our description. Sorry, that's kind of a tangent, but worth mentioning because I think she needs justice. Yeah,
but, it hasn't been a 100% success record, but I would say on the whole it's been mostly pretty positive for the work that we've done. But beyond that as well...
I focus on the negative because I like to win them all. Which is probably not great for somebody promoting something. But that's
no. Not the best marketing instincts. We saw some interesting things with cases being reviewed or overturned for procedural reasons related to what courts decided to do sort of ad hoc to deal with COVID.
Right.
A couple of cases in particular in Massachusetts and California that we talked about previously. I'll link that episode in the description later when I remember which one it is. But basically where judges refused to let people come in person and didn't take adequate steps to allow for effective teleconferencing. So there was an instance where a mother in a custody trial was basically unable to even speak to the court because she didn't have cell reception. And had to drive around the city of Boston looking for a place where she could talk to the court.
Right.
And, was effectively unable to give testimony. Thankfully, they decided they would revisit that case.
I'm glad she got representation on that one. Remember, that was our concern, and we talked about it last time, was whether or not she could even get competent counsel on appeal. But I guess she did and was vindicated as she should have been.
Yeah. And there was a case in San Francisco where, the judge insisted that they do only telephone, not, no video, because he was afraid that someone might record the trial.
Boy, that's harder on video.
And
I think we commented that last time, too.
We may have. But where, the defendant felt that he wasn't able to defend himself to the, the fullest capacity without being able to, show his face. And that makes a lot of sense. That's a big part of communication. Again, thankfully, they decided to at least look at that case again. I'm not sure whether that's been decided in the long run, but it came up for review anyway.
And we've seen, so with respect to a lot of these mandate. I don't know what to call them, for lack of a better word, mandate cases, like mandatory vaccination, mandatory testing, whatever you want to call those. The issue here is most of those so-called mandates, it's really a bad word for them, but I think we talked about that in the past. But most of these so-called mandates are imposed pursuant to state law. So we've sort of been working our way through in a lot of these states and getting favorable rulings in many of them. Now, there have been unfavorable rulings as well, but I would say that over 2022, the course of those rulings has tended favorably to the plaintiffs in those cases. So people bringing the lawsuit saying, you can't make me get vaccinated. There were a few really big ones that came out of New York very recently. Colorado's had some very favorable rulings on that. Even in California, we've had a few victories on that. But, there's a lot of work still to be done. But prior to 2022, we had not seen really any rulings on these COVID-19 issues. So that's a huge development of last year. Something to keep watching because it's not done.
Yeah. All right, and we do need to keep it moving because we've got several of these to get through. Next up on the list, we've got basically election law and election procedure becoming a major hot-button issue.
Yeah. So that was obviously a huge scramble in the wake of 2020. After November, tons of lawsuits were filed, but it was very last minute. They were all on shortened notice. A lot of the evidence wasn't really heard. We've seen a lot more election lawsuits coming up in the years after that. And particularly, there were sort of the ones that were based on the November 2020 results that kind of percolated for a little while and ultimately fizzled out. Most of those aren't really still going on. But then in 2022, we had another election. So a lot of the strategies and lessons that were learned from 2020 were able to be implemented in 2022. We kept telling you guys that people said there's no hope in bringing election challenges. The courts have rejected it anyway. We lost. Throw up your hands. Give up. Don't try in the future. It's exactly the wrong attitude because 2020 established precedent for a lot of these things that can then be applied in subsequent elections. And that's exactly what we saw going on in 2022. And there's a few big cases we want to talk about along those lines. First one is a case we were actually involved on. That's David Eastman's case. So David Eastman is a legislator from the state of Alaska. He's a Republican legislator. He'd held his seat there for quite a while, but he was present at the January 6th protests against the Trump certification in January 6th, 2021. And I guess is also a lifetime member of the Oath Keepers. Well, his political opponent, who actually was not a member of his district, so it's questionable whether or not he actually had standing on this case at all. But that was not an issue the court considered, so ignore that. But his political opponent basically challenged his legitimacy to hold office under a provision of Alaska's constitution. That's an old sort of McCarthyist provision prohibiting anybody who advocates for the violent overthrow of the government or is a member of an organization advocating for the violent overthrow of the government to hold political office within the state of Alaska.
Yeah.
And we ended up winning that one. That case went in our favor. He can still continue to hold office. We went on free speech grounds, basically, that he has a right to associate with whoever the heck he wants. So it makes no difference whether or not Oath Keepers is an organization that advocates violent overthrow of the government. He would himself have had to say something advocating for the imminent overthrow of government. So, like, join me, people, let's storm the Capitol, something like that, which obviously he didn't do. He gets to continue to hold office. Another big lake on this point is Kari Lake's lawsuit. So Kari Lake was a contender for governor of Arizona. Her opponent, the Secretary of State, the then Secretary of State, Hobbs, so, a little bit of a conflict there since Secretary of State administers the election, right? Mm-hmm. And then it turned out on election day there were all kinds of procedural problems that went on. People had to wait in line for multiple hours to vote. Lots of people went home. Lots of people saw the news about that, didn't vote at all. Well, it turned out the majority of those problems were the result of totally foreseeable, predictable, and in fact, things that they had predicted and did nothing about. Specifically, the ballots were printed incorrectly. Basically, 20-inch ballots were printed, scaled down to 19 inches, such that the ballot scanners could not scan them. So these ballot scanners were all having problems, throwing out errors, creating a huge backlog here, all of which could have been prevented if the Secretary of State and the County of Maricopa had done the legally required logic and accuracy testing on these ballot scanners, but they didn't. Obviously, an irregularity in that case has gotten some traction. We talked how a lot of the election lawsuits in 2020 were just thrown out before the evidence was heard. We actually got to the evidence on this one, got a negative ruling, but it did go on appeal, and that appeal is still currently pending. So
Yeah.
I think I did a lot of work on that reply that was just filed last week, or when this comes out 2 weeks ago on Tuesday. Hearing's coming up, so we'll keep you guys updated on that one.
And I want to just take 1 second to mention sort of broader perspective here. One of the things that I think we have, as an organization, have tried to emphasize is the importance of actually abiding by electoral procedures.
Yeah.
And that's, it's one of those things where it's the easiest thing in the world to just sort of let irregularities go by because, who really knows as an average voter what the procedure is supposed to be? You show up, you do what they tell you, typically. Mm-hmm. And B, it's such a rare event, too. There's only...
It's fairly complicated, too. If you look at, everything that's involved in disseminating ballots, collecting ballots, counting ballots, fairly complicated.
Right. But that means that it's of, tremendous value to have at least a decent percent of the public be aware of issues around electoral procedure, be ready to sort of pay attention to those things, because it's so easy for things to go wrong.
Well, that's what excited me about this case. Is I think that particularly in 2020, way too much emphasis, mostly by the media, less so by the actual lawsuits themselves, but way too much emphasis was placed on the idea of fraud. That the election was stolen through people casting fraudulent votes. I don't think there's really any way in most elections to credibly prove that people cast fraudulent votes. I just don't think that's something that, we have a secret ballot. How are you going to prove which ballots are the fraudulent ones and which ones aren't? You can't really. The reason why we have very carefully spelled out and what ought to be very carefully administered election procedure is so that you can't bring allegations of fraud down the road. We make fraud very difficult to commit by having good procedure. Now, I think there are definite defects in a lot of the procedures that we have. Failure to require, voter any kind of ID before voting, I think, is a substantial failure of proper protocol. But then there's also things that are, in fact, already laws that by many states are not enforced. And Kerry Lake's case was a great example, I think, of the second kind of problem, which really sheds light on the first kind of problem, too. Because, if these voter machines are only causing substantial delay because they aren't following the requirements with respect to those machines, are they really doing what the taxpayer funded them to do? Probably not. Yeah. So I think you see both kind of problems with that. But certainly when they don't do legally mandated logic and accuracy testing, that's a real problem.
Yeah. And, so again, just to sort of give greater context here, the point here is not that you should be concerned when the political outcome that you wanted doesn't happen, and you can maybe look at the voting and say, oh, there was some, this went wrong or that went wrong. The point is we all want to have confidence in our elections.
Yeah.
And regardless of who's winning them, we should all have a vested interest in knowing that the election was carried out fairly by the book.
Yeah. I mean, that's how we know that it's secure. That's how you prevent people from claiming fraud took place, is if you have good procedures to make sure that it's prevented. And when you don't, when you have these machines that people already don't trust, right? Because there's people out there that say machines are inherently unreliable. You got to have hand counted ballot, paper ballots for everything, paper trail for everything. I'm kind of sympathetic to that view, actually quite sympathetic to it. But, given that we're going to have machines, those machines have to be something people can rely upon to be good. And if you don't do anything to say, when we plug in vote for a candidate and then scan in that ballot, does the machine actually record a vote for a candidate? They're supposed to test that prior to the election to make sure that the machine does what it's supposed to do. They didn't do that. And that's obvious from the fact that they printed all these ballots that wouldn't scan properly.
And so, all right, so
here's the funny part. They claim, so in our we say you didn't do logic and accuracy testing. You know what their response to that is?
No.
We did logic and accuracy testing on these machines years ago.
Yeah, famously, machines never break down over time.
Right, years ago we did that. I thought that was hilarious,
Yeah, that's I think they call that computer illiteracy.
Well, also legal illiteracy, because the elections code requires they do logic and accuracy testing prior to each election. That doesn't, that doesn't mean, I guess, technically 1900 is prior to every election that takes place after 1900. But I think the clear intent of that law means prior to each election you do it.
Yes. Anyway, last point on election law, and this case is still to be decided by the Supreme Court. But Moore v. Harper, which is a North Carolina related case, you'll probably hear us talk about that again in the future, because it's going to very likely test what they call the independent state legislature theory. You've been on record before as saying it should just be independent state legislature fact.
It's very clear in the Constitution, in the manner that they shall direct. That's.
Yeah, but basically, the question here is, how do states get to draw their electoral maps, and can the judiciary of a state or the governor of a state just decide to change the map or throw out the map that the legislature brings to them?
I really wish you'd had Chevron right after this one, because the argument is precisely the opposite, right? Because in Chevron, the very same people who are arguing that the legislature should not have plenary power to redraw district lines and the court should be able to review it are saying that bureaucracies should have plenary power to do basically whatever the heck they want, and the court shouldn't be able to review it.
Yeah, so keep that in mind for when we come to Chevron doctrine a bit later in the show.
It would seem that, at least some people in our political system seem to care a lot more about the outcome than about principle,
Well, that's startling to me. I would never have believed
that's not us. That is not us at all. It's I would love if a Democrat who feels that they lost an election unfairly would come to us with an election lawsuit. I think that we'd probably be more likely to win on it. I would prefer to have the results overturned for a Republican in favor of a Democrat, frankly.
We should move on, though, to our next topic, which, I wasn't quite sure how to encapsulate this neatly in a phrase, but we saw a number of legal issues arising that sort of test the relationship between state and federal authority.
Yeah. Not as bad as the nullification crisis in the 1840s. Certainly not as bad as the Civil War or the war between the states, whichever you may prefer. But certainly we have a lot of instances of states basically ignoring federal law, and interestingly, state courts ruling in accordance with state law on those points, which, we've talked before about the Supremacy Clause. If state and federal law conflict on a point on which the federal government has legitimate constitutional power, the federal law trumps. Now, if it isn't within their legitimate constitutional purview, it was never a valid law to begin with. Of course, the state law is going to supersede. And I'm not going to give my opinions about, which of those things is true in any of these instances. I just think it's significant and relevant that state courts and states are becoming a lot more likely to contravene federal law on various points and doing it much more often.
Yeah, and, I think the most obvious and sort of like quote-unquote clean example of that, so to speak, was a recent Colorado ballot proposition, I think from November, where they put it on, they asked their voters to decide should they legalize the use of magic mushrooms, to speak colloquially,
the kind that Mario uses, right?
Maybe, there could be some subtext to those games that I haven't been aware of.
Different kind of magic mushrooms. The I don't know how you pronounce it. The psilocybin, maybe?
Psilocybin or psilocybin, I'm not sure, but, the hallucinogenic or psychedelic mushrooms, basically.
Yeah, hippie stuff.
Which are federally illegal. They're Schedule 1 substance, so, there's basically...
Like marijuana. We saw this for years with respect to marijuana. Yeah. Many states, more and more states, decriminalizing or even fully legalizing marijuana in contravention of federal law. Because remember, it is still a felony, a federal felony to possess marijuana. Lots of lawyers, even in California, where it's pretty much fully legal, will not get involved in helping out any business that's involved in selling marijuana. Yeah. Because you're jeopardizing your ability to practice law by doing that, because you've sworn an oath to uphold federal law. So, I'm not going to give my opinions on that either. That's probably not the subject for this episode. But anyway, that's extended beyond marijuana at this point, now to the psilocybin mushrooms. Is there no end to...
But, yeah, it is an interesting... So, you alluded to one of the complications that arises from that, which is, people getting involved in businesses. In Colorado's case with the mushrooms, I did a little digging. I think that they haven't permitted retail, but you can grow them.
So you can't get them at Walmart yet?
No.
Okay.
But they're permitting now people to raise these mushrooms to consume them for their own use and so on. You can't traffic in them under their new ballot.
I find that very funny because what that shows is deference to the commerce power, the congressional commerce power. but well, I guess Scalia did uphold the marijuana regulation under the commerce power.
Yeah.
So maybe this is okay. Maybe they're looking for a federal lawsuit against it so they can see if it falls outside the commerce power. I don't know.
Possibly.
Because this was never an item of interstate commerce, but I think it wouldn't really be any different from marijuana. So I think they'd probably get the same ruling on that.
Listeners who remember us talking about the Commerce Clause in the past will probably, recall that the Commerce Clause has been pressed beyond what it seems to be for.
Yeah.
Any number
May
of
regulate
times
commerce
in the
between the
past.
states, can apply even if it isn't commerce and even if it isn't between the states. So
Exactly.
yeah.
Maybe these people would be buying this illegal substance from other states if they weren't growing it themselves. There you go.
Or so, I guess there's like some mushroom. Maybe it's not a mushroom. Some fungus. I know they say it's the world's largest organism. It spans like 8 states or something like that. So maybe the mushroom itself is interstate commerce. Who knows?
I think it is a mushroom.
Maybe its mere existence is interstate commerce.
I think it's predominantly under Oregon or something like that. I also don't think
could Oregon regulate the Washington portions of that mushroom? That's just Gibbons v. Ogden again at that point. That's rather than interstate waters, it's interstate fungi. I don't know.
Yeah, I don't think that one is a magic mushroom though.
Well.
Probably not to directly.
We'll have to save that challenge then, I suppose. That was not a legal development of 2022. But along the lines of, I guess, what do we want to call it? I don't want to call it state usurpation of federal law because I think some of these instances they are valid. I think it's valid to claim that Congress never had any authority to regulate that thing, so it does fall back to the states.
I think conflict is probably the closest shorthand that we've got.
State and federal conflict.
But so Biden v. Texas involved Texas and a group of other states on the Mexico border, challenging basically because the Biden administration had said it wasn't going to continue to follow this remain in Mexico policy that had been set up under the Trump administration. Which is that
Mexicans have to remain in Mexico.
Not quite. What did that to do? People, coming to the border claiming to be seeking asylum, and basically, the way the rule was written said either they can be detained in the U.S. until their case can be heard and you can make a determination on whether or not they're going to get asylum, or they can remain
if they want to be free.
The border.
If they don't want to be in custody, they can remain in Mexico until their case is heard.
Right. And so the Biden administration said, we're not going to do that. A combination of we don't want to and it's too expensive to detain this many people.
Well, then they could remain in Mexico.
Right. But we're not going to also, force them back across the border because I forget what the justification was.
The Democrats, ever wary of frivolous spending, argued that it was too expensive. The famously fiscally conservative party.
That may be a bit too partisan.
No, look, we call it fiscal conservatism for a reason. I think anybody could see that it's totally specious that they suddenly now they claim they care about the expenditure.
Well, regardless of the reasons, among other things, Texas and the other states claimed the administration hadn't properly followed the administrative rule, which is this process known as notice and comment. So you give notice that you're going to change a rule or implement a new rule, and you ask for comment from the stakeholders, which in this case would obviously include the border states.
We talked about that before.
That's where
usually it's just lobbyists that comment. I think we gave the example, of chocolate or maybe ketchup.
Yes.
When you were talking about it before.
Ketchup. We talked about Heinz.
Yeah.
But at any rate, in this case, I think the border states would reasonably say, hey, we want to weigh in on this because, when people cross the border, they come into our states. So
it affects us and not other states. So
yeah. So that was one prong of the challenge, basically saying you didn't follow the administrative rules that are in place. But it was also an interesting circumstance just in general because it was states seeking to enjoin the federal government to continue enforcing a policy rather than trying to get them to reverse a policy,
which is very rare.
Policy.
It's not too common to do that. So anyway, final disposition of this case. It's fairly complicated. There were 3 issues heard. Basically, it was whether or not the court can even compel the federal government to enforce this law. And on that issue, Texas wins. The court can absolutely do that. Second issue we didn't really talk about. I think it's the least important issue, though it is the one where Biden wins, is that the law in question does not, as such, compel the secretary to hold people in Mexico prior to their prior to the deportation hearing. I think nobody ever really claimed that. I'm not sure why that claim was in here. And then the third point of whether or not the actual comment and review process was properly followed, that was remanded back to the lower case, or to the lower court for further adjudication, because the facts of that had not yet been heard. Things typically go that way. If the other issues are dispositive, then you don't even get to the evidence. I don't know if that's clear. It comes up a lot, so that's something you should probably be aware of. If something can be decided on the basis of law, courts usually won't hear the evidence in the interest of judicial economy. So now that it's been decided that these issues can be heard by the court, it's been remanded for that evidence to actually be heard. So we'll have to wait for what's going on there. But anyway, another instance where states and what the states want to accomplish directly conflicts with federal objectives on a particular issue. The last really significant area where this has gone on is another one that we've talked about before, and that's regulation of social media companies. Now, there's a lot of, I think, public support behind the idea of regulating social media companies. Certainly in sort of the beginning of 2023 and the last few months of 2022, we saw a lot of congressional antitrust and regulatory antitrust action thrown around with respect to Google. But more significantly, when it comes to the federal and state conflicts, what we've seen is, we talked about this with respect to the Texas law and the Florida law, are attempts of states to regulate the conduct of social media companies in an arena that I think would ordinarily be perceived as a federal arena. Yeah.
And, as we talked about when we were directly addressing those, it's interesting because you've got these companies that are, I think, mostly headquartered in Delaware and mostly operating out of California for the most part. Silicon Valley. So the question, it's interesting even, to what extent could Texas or Florida do something even if their laws were found to be valid?
Right.
So, and those issues are still playing out. If you prohibit them from operating
within Florida or Texas or wherever, is that an imposition on interstate commerce?
Right. Yeah, exactly. I think this is not the last we've heard of social media as a legal issue, and no. I can virtually guarantee it will continue through this year and probably into the foreseeable future.
Well, and it now seems the federal government's, at least on the antitrust aspect of it, less so on, I think, the censorship aspect of it, which I think was what both the Texas and Florida laws were aimed at. But certainly on the antitrust aspect of it, they're seeing a lot more federal interest on that, too. So state and federal interests may end up converging on this issue. I think that really the federal regulatory interest in it has been with respect to the fact that Google basically has a monopoly on online ads. I don't think that's entirely fair. Come on, Meta's part of that monopoly too. but basically those two companies control all online advertising.
More or less.
And advertising comes down to a speech issue as well. Mm-hmm. So I think very likely these issues could end up getting consolidated down the road, and that's something to watch for sure.
All right, so next on the list, this is presumably, everyone would guess that we were going to talk about this one. The end of the Roe v. Wade, and more importantly...
Oh, I thought we were talking about Chevron, and I was like, yeah, everybody could guess that one. That's
Well, because you already mentioned it, but that's next. That's after this. The end of the Roe v. Wade...
No, was that big? That was big news last year? I didn't hear about it.
As we commented at the time, you liar, because we talked about it on the show. It's, Roe v. Wade, it's sort of interesting that people stuck on the term Roe v. Wade when really the controlling law much more immediately was Casey v. Planned Parenthood. Yeah. But whatever you want to call it.
The reason Roe v. Wade was what got in the popular consciousness is it was sort of a nuclear bomb in the jurisprudence. I mean, it was huge. Like, from all of a sudden, it's illegal in the majority of states to it is now federally mandated that it must be legal in every state, and there's nothing Congress can do about it. This is a constitutional requirement. Like, that's a monumental shift. So,
and that's why whatever your feelings on, abortion law, what you want to be the case, what you don't want to be the case, I thought one of the most interesting things was this sudden reaction where it was like, oh, this is such a huge change. How can they possibly do this? The court has gone too far.
They did it before.
Such a big... Well, exactly. Right. And so, from my perspective, and, to be fair to a lot of the Democratic commentators as well, they said it just shows that, Democratic lawmakers got complacent because it was, oh, this is a constitutional right. It has to be everywhere. And a lot of them probably did less than they might otherwise have done to just implement the legislation they wanted to see in their states. And so I think that shows the dangers of relying on the Supreme Court to accomplish your policy positions.
Or any one thing in our government, right? There's separation of powers and checks and balances for a reason.
Yes, but to be fair, I think the thing you should rely on the most as sort of a durable form of policy is law.
For your policy, or you mean not for your policy positions, but
well, in terms of a question like this, where it's like, what do you want to be the law?
Oh, yes.
Probably the best way to accomplish that is to actually legislate.
One would think. Well, they're doing that now. So,
yeah.
Anyway, that's a big one. Particularly Thomas's concurrence in that case, I think is a huge development because, his response to this, what some would call sort of a monumental shift in jurisprudence, is bring it. I love hearing this stuff. We want to look at Griswold. I'll look at Griswold. We want to look at the rest of them. I'll do it. So bring me your 14th Amendment challenges. Let's get rid of substantive due process once and for all. That would really be a big change in our law.
It would. It would.
It's not typical that a Supreme Court justice will say, we'll invite people to say, this case went pretty far, but I'd really like to go further. Please let me do it. But Justice Thomas, we will answer that call. We will bring those cases, and you will get to hear them, provided that you grant cert.
Have we done an episode on substantive due process specifically? I don't think we have. Not. Maybe we should consider that at some point.
That'd be a good one. Yeah.
Yeah. So you're right that aspect of it got a lot of rightfully so, it got a lot of attention, a lot of negative attention, it must be said, from the press. Thomas's concurrence.
I think he's fed up with it at this point. He was really incensed about that court leak. That was a huge deal. The court's been sort of above the political fray on a lot of these things for a long, long time. The idea that they would leak an unfinished Supreme Court opinion is really pretty outrageous. So he figured, you know what? I'm done with all this. I'm just going to say it. I'm going to say it. We've gone off the rails on this stuff, and I want to rein us in.
Yeah. It's been, he's definitely become a lot more expressive the last few years.
Well, I think for over 10 years straight, I think he said nothing at one point on the Supreme Court. So, I'd say he's gotten a lot more expressive.
Well, that was true in argument, but even as you rightly point out in this, written opinion, it's probably more overt and voluble.
Oh yeah,
than he tested.
It's great. I love it. But we posted a super reel on our Facebook page of all of his best moments from 2022. That's a legal development in its own right. Is Justice Thomas is
finding his speaking voice.
Yeah, and it's funny because he'll ask things that aren't strictly relevant to the case that's in front of him. So he thinks it's stupid.
Anyway, to keep us moving, just the last point I want to hit on this issue, and you'll remember that the case that overturned the Roe and Casey precedent was Dobbs v. Jackson's Women's Health Organization. Mm-hmm. So we heard a lot about the Dobbs decision, and there was a lot of commentary. A lot of it inexpert, I would say. from
to put it mildly. But, like some of that commentary from Justice. He will never be a justice. From Merrick Garland was sort of unbecoming of his office, but
and from the press in general, a lot of pontificating from people who probably could have saved themselves some of the embarrassment on some level. But one of the most common things that we heard about was, what about stare decisis? And so I just want to take a minute and let's talk about stare decisis, which is a legal term that
means let the decision stand. Yeah. Yep. That's our entire system of precedent is based on stare decisis. The fact that earlier decisions have gone a certain way governs future decisions. That way you have consistency in your legal system, you have laws that are predictable, and your laws get clearer and clearer with time, because any ambiguity ends up getting fleshed out through other cases, and that's there's a lot of value in stare decisis.
Yeah. So the big question, though, that a lot of people were raising is, why does this not violate stare decisis, or if it does, why is it now permissible to do that?
The court actually directly addressed that in its.
Well,
I mean, that's like the entire issue of their ruling is
right.
that, like, Kavanaugh goes through these, when these elements are met, overturning precedent is appropriate, and then concludes that they've been met. So, like, if you read it at all, I think you probably wouldn't ask that question. You would just say that I think that they were wrong, that the standards were met for overturning past precedent. Or maybe you'd say maybe there should never be standards for overturning past precedent. I'm a big fan of segregation and think they never should have gotten rid of it. That's my opinion. Never overturn past precedent. Please, that is not my opinion. I'm quoting what these people may think.
I think we usually say paraphrasing when we're not directly quoting. But,
I think that the court was right to overturn Plessy v. Ferguson. I think that segregation was bad, and that Plessy v. Ferguson was never rightly decided. But some people would have you believe that overturning precedent is always wrong.
Yeah. So anyway, I suppose that's another point to bear in mind here is, the press sometimes has a shorter memory than you'd like them to for Supreme Court history. And, when you start talking about, now we have fewer constitutional rights than we used to have, bear in mind that the court used to think that you had a right to force states to return your slaves to you if they escaped. All that to say, yes.
Yeah, they used to think there were all kinds of things. I thought there was a right to, I don't know.
To segregated schools, among other things.
I thought there was a right to property and people. That's a right that we no longer have.
Right.
A lot of people didn't like that. A lot of people were very upset. They said their entire way of life. They'd made a lot of very big and important decisions around being able to own people. And I don't doubt that they did. Their entire decision to get involved in the cotton industry was based on being able to make somebody else do all the work for them. I understand that. Similarly, people make a lot of big and important decisions when it comes to abortion. But that's not necessarily sufficient to say that it shouldn't be overturned.
Yeah. And, all that to say, yes, the court should be very circumspect about when it chooses to overturn past precedent. That's, I think we can all endorse that idea, but that doesn't mean that past precedent is literally always set in stone forever.
Or Commonwealth v. Hunt also overruled an important, the right of business owners to repress labor or collective bargaining, to repress unionization. Commonwealth v. Hunt got rid of that. There's another time they got rid of a right. I think that most of the people complaining that they've gotten rid of rights here probably liked it most of the other times they got rid of rights.
Yeah. I think that more than anything. And, I'm actually working
They usually love taking away our rights. It's like their favorite thing in the world. Just not this one.
I'm working on an essay that will hopefully go up on the new website that has to do with this issue, so I'll keep some of my material for that.
Suddenly they care about your right to a freedom of action? They've cared about that exactly 0 other times.
You're getting a little hot.
I just find it totally disingenuous. I think
you're getting a little agitated here.
That's bugged me for a long, long time. That's my personal opinion on this. But
anyway, before we get too deep into the weeds on this, we should move on to our next topic. And you've been looking forward to it this whole time. I'm very happy to announce to you that we're finally going to talk about Chevron.
Yeah, that's probably my favorite. Dom's is huge. I don't want to downplay that. That was huge, socially, culturally. But look, Chevron in terms of legal doctrine has been the bane. That has been the thorn in the side of any lawyer fighting for constitutionally limited government for decades. It's absurd. The idea that these totally unaccountable, unelected bureaucrats would be deferred to over and above the explicit words of Congress.
So let's take a second and say what Chevron doctrine is, because you've sort of jumped into it there.
Yeah,
but
sorry.
Basically, Chevron doctrine, which was a precedent that the courts had since the 80s?
I think 86 Chevron was heard. Could be wrong on that.
Somewhere
Don't
around
quote
there,
me.
anyway. Somewhere in the 80s, I'm almost positive, though. That basically says when a federal agency has an interpretation of the law that.
Yeah. So the same thing we were talking about earlier,
something.
that whole regulatory process. That's Congress makes a law. Congress, say that they want to regulate the size and color of lollipops that are produced. So they create the Lollipop Regulation Bureau, and they say we don't want to have lollipops that taste bad or that are ugly. And that's what the law that Congress passes says. Then what the regulatory agency would then do is they would, through that public comment process, would proliferate regulations advancing that goal. So they would say things like, here are the acceptable range of colors for lollipops.
Yeah.
So they say, here's the range of acceptable colors that you can have for a lollipop, and they might say, here are the acceptable range of flavors for lollipops. And they might say something like, licorice is not an acceptable flavor, because, some people love licorice. I personally think it tastes horrible. My dad loves it. I can't stand it. I think it might be literally like one of those things where you could taste it or you can't kind of thing. Like with broccoli,
maybe,
it tastes bitter to some
cilantro.
people. Yeah, cilantro is another good example. But they say, you can't make broccoli or cilantro or a licorice-flavored lollipop.
Yeah.
Well, the court would say that as long as that interpretation is a reasonable interpretation of what Congress had enacted, courts are required to defer to the judgment of that bureaucracy.
Yeah, and there's two prongs to it. That's one, and that's the much more important one, especially for what we're going to talk about. The other one is that if Congress has at some other point explicitly legislated about the issue, then you don't have to defer either. But for practical purposes,
if there's another law from Congress saying that it isn't their intent, then sure. If they make a law that says licorice flavored lollipops are the licorice flavored, that's harder to say than you'd think. Licorice flavored lollipops are the best. In fact, we're going to subsidize them. Then they probably can't prohibit the licorice flavored lollipops.
For practical purposes, yes. Basically, the idea was, if a reasonable construction, or I think the phrasing has at least once been rendered a permissible construct.
Yeah, that's the Brand X precedent. I mean, it's been expanded beyond Chevron, but it's still referred to as Chevron deference. We don't need to get into the case law here. We've done that before. Which episode was that?
That was
you can find
one of the early ones.
I think it's called Chevron deference, so you can.
We'll link it somewhere, but it was one of our.
No, it's whatever one has ketchup in the title. Click on that one.
Yeah, ketchup nerds.
Yeah, ketchup nerds. That's right.
But so basically, though, for the longest time, it was if you can hypothetically read the law in such a way that it would permit the agency to do this.
Yeah, if you can contort your reasoning such that it could be read to mean that.
I actually think before you started on your hypothetical, I was going to say something. Well, after you named the idea of a lollipop bureau, I was going to say they say there's only one acceptable flavor because only one lollipop tastes good, and that's licorice.
Yeah, that's like, well, Congress did say only lollipops that taste good, and
if the Lollipop Bureau has all the experts on lollipops, so they must
had
know
public
better.
comment. And what do you know? The Licorice Producers of America spent $200,000 researching what flavors people like, and it turned out that 90% only eat licorice. So
which I say that specifically because I also hate licorice. But anyway, so for a very long time, that was basically the official orthodoxy of the court. Like if the agency could show more or less that the law didn't forbid them from doing the thing necessarily, in sort of direct terms, then they could just do it.
Which basically stripped the court of judicial review, right? So we've talked a lot about non-delegation. That's basically when executive agencies strip Congress of the ability to make law. That's sort of a little bit involved here, but between non-delegation and Chevron doctrine, you have executive agencies stripping Congress of their ability to make the law, and then stripping the courts of their ability to review it. So we still need to walk back non-delegation. There was a lot of that in 2021. And if we'd done this episode last year, that probably would have been our number one thing for legal developments. But this year, we chipped away at the other end of it, and that's the Chevron deference. So what were some of the cases that did that, David?
Yeah, well, one of the most important ones was a case called National Federation of Independent Business v. Department of Labor, and there were like 5 or 6 other defendants, individual officials. But you may remember this one as being the OSHA vaccine mandate case. Yeah. That was sort of how it got the headlines. But basically, OSHA implemented this rule saying large businesses in America, and I forget how they defined that, but I think it was like over a certain, over X number of employees, you have to implement either mandatory vaccination or some kind of testing and control scheme in lieu of vaccination. And the court reviewed this, and it didn't say, you know what, you don't have the authority, Biden administration, to implement this kind of requirement, period. What they said was, OSHA
can't do it.
Definitely. OSHA can't do it.
It's the Occupational Health and Safety Administration.
Yeah.
COVID is not a workplace-related risk. COVID is a generalized risk. You could get it anywhere, and you could carry it to people anywhere. It is not the sort of risk for which Congress's enabling statute that creates OSHA and empowers OSHA created them to protect against. So it's outside their authority.
So, and that was what OSHA's argument was. Basically, it was like people could get it at work. Therefore, it's an occupational hazard. And
so they can create laws against getting drunk or against alcohol, because people might bring alcohol to work.
Right. Or, or other kinds of drugs, or, someone might, bring a hammer to work and hurt somebody with it. It's
right. That is not a reasonable interpretation of Congress's intent in creating OSHA.
Right. Yeah, and I thought that was actually, this was another one where there was a lot of fairly predictable press outrage about it, but I actually thought the court was very restrained in this ruling, where they didn't
I think so, because they didn't overrule Chevron. They just said that this didn't fall within Chevron deference.
Right, and that brought up the issue of this thing that people talk about. You may have heard people talk about this idea of major questions doctrine, and that was, alluded
which is essentially not a thing.
Right. It was sort of alluded to in the opinion on Chevron, but not really. But the press made a big deal about it. And they said, they're using this made-up doctrine to
the press both created a doctrine the court had not referred to and then called that doctrine made up.
Right. And
that's kind of like, David, you're a lexomancer, right? No, that's not true. Lexomancy is made up. Well, he never called himself a lexomancer. Anyway.
Okay. The point being, the court has referred to in the past, and I think also in this opinion, the idea that, if something does have vast impact.
It was probably not within Congress's intent when they created a law not referring to that thing of vast impact, right?
Right.
So, if they created an organization that was supposed to, I don't know, promote agriculture, the agriculture agency, say, and then they decided that the best thing for agriculture was if we killed 80% of the people in the United States. If that were something Congress wanted them to do in regulating agriculture, they probably would have said it, because that's significant.
Yeah, and so to me, what this really comes back to is that second prong of the Chevron test, which is this a reasonable interpretation of the statute? Not a new doctrine that's being imposed. I think it's just
it's not reasonable to assume Congress is legislating matters of great social import when they do something like create a new post office.
Right. Or so, we created this agency to, regulate common workplace hazards. And so it's like, they're going to be concerned about what kind of ladders you use in warehouses and, that sort of thing.
They're also going to outlaw contraception.
Or rather than that thing that existed to make sure your ladder was safe is now going to require you to undergo medical care that you don't want.
The thing that would make ladders the safest is if we surgically installed a titanium cord into people's hips that would make them permanently attached to those ladders. And OSHA is going to now require that. It doesn't matter that OSHA can say that makes you safer at work and is directly related to a safe workplace. That was not within the purview of what Congress was authorizing them to do.
And it's not a reasonable interpretation of it. And I think that's where
even though that actually is related to workplace safety.
Yeah.
Right. Probably would make you safer. I don't know. Not a doctor. Not that kind of doctor anyway.
Right. So that was probably the biggest one, but there was another fairly big one as well. American Hospital Association v. Becerra, which had to do with the authority of the Department of Health and Human Services to make their own rules for their finances. The details are pretty boring there, and it gets nitty gritty. And we also
that's a great one. Get into them, David.
But basically, the law that they were relying on gave them two options for how they would choose to refund hospitals for drug costs, and they chose to, pick elements of the one option and elements of the other, and rather
like a Chinese menu.
Sort of, yeah. Like you pick from your starters, you pick from your mains, and that's the lunch special. But yeah, rather than pick the options,
Congress did not present it as a column A, column B choice.
Right. It was you can do this or you can do that. Right. They chose to do some of both, basically, and a group of hospitals sued them for that, saying, you didn't reimburse us the right way. You don't get to just pick and choose this way.
And the court said no substitutions.
Basically, yeah, it's a fixed menu.
Yeah.
So very similar result there. Probably fewer headlines about that one just because it couldn't be tied into COVID-omania, which was obviously all the rage. But that was another.
They couldn't make that match a political agenda. We could have done the first one as part of our thing on the COVID cases, but I guess it fit better here.
Yeah.
So. There were also several circuit court decisions that were really big on the issue of Chevron deference as well.
Yeah.
We discussed a couple of those on this podcast. I'm forgetting the names of those cases now, but this is really. I mean, we're only citing a few cases with each of these items, but though understand those represent,
bigger
in some
trends.
cases, dozens of others.
Yeah, and I think you're right that we did see more willingness. I think probably in part because the Supreme Court had signaled that it was more willing to sort of limit Chevron deference.
I think some of them were before the Supreme Court had even. I think this is riding the tide a little bit of some of the non-delegation stuff we saw last year. I think that people are becoming aware that we've got tens of thousands, literally tens of thousands, of totally unaccountable bureaucrats in our system who are not subject to the will of any voter. And really, if you allow for unfettered interpretation of Congress's statutes, they're not bound by Congress, they're not bound by the courts.
Right.
Which starts to look a lot like a dictatorship.
Yeah. And so for me personally, I think probably the most important legal trend, and we talked earlier about Dobbs and its sort of social importance, but I think as far as law goes, I think this changing of the tides on Chevron is probably the biggest trend.
I agree. Although as much as I appreciate Clarence Thomas's invitation to bring all these substantive due process cases, that could have a huge effect on the law down the road. I wish in Dobbs they'd gone a little bit further and overruled Griswold in that one too. I'm totally with Justice Thomas on that. If they'd overruled Griswold, I think that would have been huge in terms of the legal ramifications. But if they're just doing Roe, that has a huge social implication, but not necessarily huge legal ones.
Right.
So we'll have to see on that one. If they actually do take up those Griswold challenges, that may end up being a monumental shift. I kind of hope it is.
Yeah, well, time will tell. All right, and with that, let's move on to our final one. It's the death of the lemon test, or the ostensible death of the lemon test. We'll get into that in a second.
But is it?
But
bum. I'll wait till next week.
And the lemon test, which we've talked about on a few occasions, is the First Amendment, freedom of religion test. It's sort of got a weight in culture that I think goes beyond its actual legal significance, because it is sort of like a little dead-end cul-de-sac of law, where basically the court had articulated an idea that it couldn't really apply very well.
Yeah.
And so all of the religious cases end up coming under its purview, but it doesn't seem to, in my opinion anyway, and obviously I'm not an attorney and not an expert, but it seems like it's sort of a limited area of influence, but it's been a big problem for that area of law.
Well, and the thing is, everyone knows Lemon's a terrible test, which is why they keep killing it. But they never actually explicitly say, Lemon is overturned, Lemon's no longer the test. You don't want to speak too soon on this, but I think Kennedy may have done that. Kennedy v. the Bremerton School District.
Kennedy v. Bremerton, that was we talked about this one. I think maybe
it's our first
twice.
episode, right?
I think it might be, But was his name Joseph Kennedy, or am I making that up? I've forgotten.
I think it was, because I asked if he was different from the notorious bootlegger and ambassador.
At any rate, I guess we can call him Coach Kennedy. But Coach Kennedy, high school football coach in Texas, at a public school, so he's a government employee, and he,
And very differently from the more famous Kennedys, this man liked to pray.
So Coach Kennedy had a habit of praying after the games were over at midfield, and a lot of, again, interestingly, there was a lot of press reaction about this one that focused on things that were definitionally irrelevant to the case, because the court ruled on the evidence it had before it, which said like
the press was basically Coach Kennedy is very annoying, therefore he shouldn't have rights. That was kind of the position they took.
More or less. And a lot of it was also, well, the evidence on record said this, but we actually think that wasn't what happened. And
who
why
cares?
happened instead.
I mean, court's rule is the evidentiary record in front of them. So
exactly. So basically, the idea was the school eventually told him he couldn't pray on the field after games anymore because it could imply that he was pressuring the players to pray with him, and that's sort of compelled religious speech, basically. The court ruled basically that wasn't true, and in fact it was we commented on this at the time. Justice Gorsuch said actually that's doubly protected behavior.
Yeah, it clarified the hybrid rights standard from Smith, which is kind of dicta in Smith, alludes to, well, the reason why we think it's okay to not give this guy workers' comp because he smoked this drug is because if there were other rights that were involved and it weren't just a stupid thing he was trying to do, then perhaps we would say it is protected. So here, that's sort of expanded, and they say that, when two different constitutional rights, protected constitutional rights are impacted at the same time, specifically when it's free speech and free exercise, which are in the same amendment, that's something that would get heightened protection.
So that was probably the biggest freedom of religion case last year, but there were a couple others as well. Shurtleff v. City of Boston, which was this guy wanted to fly a flag with a cross on it at Boston City Hall on a pole that they normally just let people sign up to use for whatever they want to promote. The city said no, it's a religious flag, we can't do that. He challenged, he won.
So that'd be an establishment clause, but
and then the last one, Carson v. Macon, we did an episode about this one as well, which Maine had a program offering tuition aid to parents who didn't live near a public school because parts of Maine are very remote and they don't have, good opportunities for that.
And they could not prohibit that from being used in the parochial schools. Yeah.
Right, yeah. So there were some parents there who wanted to send their kids to Christian schools, and the state said, no, we're not going to do that. You can't use public money for religious purposes. And the court said, you can't carve out religious schooling just because it has religious elements to it. So all of that together was sort of taken to be a real tide shift. And, people talked about the death of the Lemon Test.
But the Lemon Clause has haunted our Establishment Clause jurisprudence for decades. Perhaps it's finally dead and buried.
Yeah, and to that end, I wanted to read directly this paragraph. This comes from Justice Gorsuch's opinion on the Shurtleff case. He says, to justify a policy that discriminated against religion, Boston sought to drag Lemon once more from its grave. It was a strategy as risky as it was unsound. Lemon ignored the original meaning of the Establishment Clause. It disregarded mountains of precedent, and it substituted a serious constitutional inquiry with a guessing game. This court long ago interned
Gorsuch
Lemon.
Is so good on those balancing test criticisms. He's the best.
But this is the part I want to focus on.
Yeah.
This court long ago interned Lemon, and it is past time for local officials and lower courts to let it lie. So what he said...
We've already killed it. Stop bringing it back.
We've already killed it. So is this latest one enough to actually kill it?
It's already dead. Stop it. You don't need another Iron Man movie.
Exactly. Or is this still just another instance where...
Frankenstein movie or whatever.
Who was it? Scalia, was it?
It's to a zombie? Like one of the most hilarious things. Obviously, Gorsuch keeps referencing it subtly here. I did a little less subtly earlier, but he explicitly refers to the Lemon Test as being like a ghoul from a late-night horror movie that is buried not quite 6 feet under, so that he can, come back. Well, the secret to his success is it's so easy to kill. So you can kill it, you can bring it back each week. He says, it comes back this time to haunt the children of what was it? Parish County School District, whichever district it was.
But anyway, so the question here is this an instance where you're like, well, look at the zombie, it's rotting, it's already dead, just leave it be, and you didn't finish it off yet again.
I think he's saying, I refuse to make another of these stupid sequels. Like, I'm not going to do it. There's been enough Friday the 13th movies. It's already dead.
You'd think, you can hope, but, will it rise yet again? I guess only time will tell.
I think they just made a new Friday the 13th movie, didn't they?
Maybe. Since I've been in the UK, and I don't want to pay to license a television, which is what you have to do here.
Are you kidding me?
No.
Be thankful for your freedoms, folks.
I got on that tangent because I was going to say, I don't know if they're making a new Friday the 13th movie because I haven't been watching TV and haven't seen any trailers.
Oh, that's right. Are we through all of our... I think we're through our top list now, right?
That was the top 6.
Okay, so what are the honorable mentions? I don't see them written here, so hopefully you remembered all of them.
The honorable mention, and we're not going to go in depth on these at all. So, just be aware, I guess, that these are trends. Delaware courts, which they come up all the time because most corporations are headquartered there. I
thought you weren't going to go into them, David.
Well, 2 seconds of commentary. Anyway, becoming more likely to compel specific performance, and if you're really interested in specifics on that,
look up the Musk case. Yeah.
Yeah, the Elon Musk and Twitter debacle. Challenges to attorney-client and executive privileges on document secrecy, that sort of thing.
Yeah, lots of cases on that. There's actually one coming up on that, too, so that may be better saved for 2024. Who knows?
Yeah. Some signs that the courts may be looking to weaken qualified immunity for law enforcement. We've talked a bit about qualified immunity before. Yep. And the last thing I have written down here, the Bruin case, which was Bruin I think it was the other way around, like New York Pistol and Rifle Association v. Bruin. That was the big case. But basically, the court signaling that it's not interested anymore in balancing tests for Second Amendment rights.
Yeah, that's huge, too. That one was really big. That one didn't make our top 7 or 6 or whatever. We couldn't add a 7th to talk about the fact that Second Amendment rights are actually not being treated as second-class rights anymore. The Second Amendment doesn't mean second class.
I'll point out to you, we're already well over time. And also, you were the one who had final cut on the ones that
we should have had that. No, I'm going to blame you. That's a big one. I didn't include that because there's really only one big case on it that happened last year. Now, we put Dobbs in anyway because I figured everybody would have complained if we didn't put Dobbs. But yeah. All right, and in case you thought we were no longer doing it, you were dead wrong. We're still going to have it this season. So gather around, young and old, shy and bold, everybody who's interested in eccentricities and craziness in the laws of America and throughout the world. Captain Kangaroo Court.
Yeah. And we are... I don't have the actual running time in front of me, but I feel certain we are well over our normal run time.
That's okay. We're only publishing every other week now. We can give people 15 minutes extra.
I'm going to limit it to one thing this time, but let me.
We could have loaded a lot of that earlier stuff into Captain Kangaroo Court. Actually,
that's fair,
like and that's English courts are kangaroo courts. Apparently,
that's part of. I'll say that was part of my thought process here. But for your information, because I'm guessing you probably do not know this, Young Thug is the name of a hip hop artist.
I did not know that, but honestly, I could have guessed that.
I thought you might be able to guess, but I don't want to presume. Anyway, the headline reads: Potential juror for Young Thug trial ordered to write 30-page essay after skipping return to court.
This is probably a good punishment, especially if he really is a young thug.
Well, it's a woman who is identified only as juror number 64 because it's an ongoing matter, but. A juror who skipped a return court appearance to be considered as a juror in the trial of rapper Young Thug has been ordered to write a 30-page essay focusing on the history of jury service in Georgia. And I just want to take a minute here to note that for the master's program I'm currently in, will require me to write something longer than 30 pages as my thesis.
Right.
My prior master's program did not. So I have actually never been assigned, despite having been, through undergraduate and one prior graduate program, to write anything of this length before.
That is insane. Wow. All right. So this random juror is going to have to write something longer than you.
Yeah. It gets pretty specific. The judge ordered the woman to write the essay with 10 primary sources and 10 secondary sources, and to submit it within 3 weeks, that's a pretty aggressive timeline, considering she's a businesswoman of some sort. She was the reason she didn't come to court when she was told to is that she was in the Dominican Republic on a business trip.
Wow.
So she has 3 weeks to write, again, a paper longer than I've ever actually had to write for a
This
course.
is Fulton County?
Yes. And he also specified what reference style she has to use, which is APA style. And that's, I don't know about you, I don't like APA style very much. I prefer Chicago style.
I honestly don't. I like Blue Book. That's I use Blue Book, so
I like the specificity here. Oh, and it also specifies software will be used to check for plagiarism. And we're not going to talk today about Chat GPT and all the stuff that's been in the headlines recently about AI and academic writing. We will talk about that at some point, I think.
Although, surprise, this entire episode was written by an AI.
Untrue. And if it had been, we should definitely look into a new AI because we rambled way too much.
Yeah, it had a lot of bias in there.
It got off on tangents.
Yeah. I don't know why these AIs believe all these election conspiracy theories.
Anyway, I think this is interesting too, is that she didn't realize she was violating, the requirements, because she says she sent jury services a copy of her itinerary, and she says, I didn't really know I was in violation until the sheriff showed up.
Wow.
Unfortunately for her, that's going to result in a pretty hefty amount of work that she's going to have to do.
I mean, she could. Presumably the judge issued this article's very unclear. Presumably he issued a bench warrant, and that's what he's requiring as bail, I guess. I don't know. Likely.
You know what this reminded me, though? I know you like the show King of the Hill.
I do like that show.
I do as well. Do you remember it was an early episode where Hank catches a guy who's trying to hotwire his truck, and citizens arrests him. He goes in to watch the trial, and his wife tells him that the judge is known for his creative sentencing, and he immediately just goes, "Oh no!" It's awful. But then he ends up sentencing the guy. He says, you like trucks so much, I'm going to sentence you to spend a month in the cab of one. And then he pauses and he goes, "An import." And then Hank sort of nods, and he's like, "All right, yeah."
Fitting punishment.
Yeah. Anyway, that's what this reminded me of. Very creative form of judicial punishment.
Yeah, certainly that. All right, well, all right. Thank you, folks, for listening to this episode of Captain Kangaroo Court, and also this episode of our podcast. We got a lot more exciting stuff planned for you guys coming up in the future. A few previews. We're going to do an episode on Jeremy Bentham, everyone's favorite talking head, or non-talking head, as the case may be. Find out what that means in the episode about. We're going to do. I don't have the list in front of me. What else, David?
We're going to talk about. We talked about the French Revolution. We talked about the American Revolution, or is it a revolution? ? We're going to talk about something that certainly was a revolution, the Russian, and the
doing an episode on federalism. I pulled it up, so I have it now. Doing an episode on the natural law tradition. That's going to be a fun one. I think we're all going to enjoy that.
You definitely will. We'll see if other people do.
Yeah.
I guess enjoy, again, ? Watching this on video, or you can tell us never to do this again if you prefer.
I don't want to see your faces. Don't tell us that. I mean, be nice about it. But
yeah, we're fragile. We're fragile men. But anyway, thanks everybody for listening or watching, as the case may be, and we hope that you'll join us next time.
Yeah, we'll see you folks 2 weeks from now.